Well, hello, Lyric Armstrong, your real estate agent and advocate. Let's see if we can get that light out the way. All right, we're back. We're having fun in Judge Simpson's court, so let's just stay there. Why leave when it's so good? Judge Simpson has his docket on Landlord Tenant, so we're going to check that out today. Do me a favor, make sure you like, share, and subscribe. As I say a gazillion times, as you may know many things because you're watching court and you're hanging out with me, inevitably there's someone who just may not know and needs to know. So share the link on all your social media so that they can get into court with us because we are on our way. Judge Simpson, we're ready. We're here. We're ready for court. We are ready for court. All right. Where did we go? Uh-oh. He hasn't opened the doors yet. Let us in. Let us in. We keep things loud, so unplug or turn down the volume, one or the other. Protect your ears.
The 14A District Court is now back in session. All those having business before the court draw near.
We are here.
Judge J. Cedric Simpson presiding.
Thank you.
Good morning. Court calls the case of Arbor Meadows versus Efren Hussein.
I'm here,
Your Honor, Laura Kubi on behalf of plaintiff Arbor Meadows.
Is there, Hussein and
She's not.
Ali Bar.
She's not part of it.
What's your name, sir?
Irfan Hussein, sir.
All right. And
Okay.
the last hearing I had that the defendant was going to pay this off. What happened?
That is correct, Your Honor, but as of today's date, we still have a balance of $1,468.52 plus court costs of $155 for a total of $1,623.52.
And that includes September rent, counsel? I'm sorry?
That is correct.
How much is his September rent?
I'm normally pull up the ledger. His September rent is $776, but there are some utility charges, sewer and water. Do you want me to give you the breakdown?
Well, what I'm wondering is, when they said that they were going to pay it off, they were at $2,067. So how much was paid between the last hearing and today?
Can you tell me that balance one more time, please?
I had a balance the last time of $2,067.22.
Okay, and defendant on August 29 made a $1,300 payment, leaving his balance at $767.22.
Okay. Is that right, sir?
No, that's not correct. August, I paid a total of 13. I paid 1326 altogether. I paid $26 yesterday as well. On August 30, I paid 1,300. August 31st, I paid $26 extra. And then Barrier Busters is following me. Barrier Busters told me to pay 1326, and Barrier Busters told me that they would pay the remainder, $742.
In the chat, it was a very interesting comment, which I kind of agree with. Is like, how do you pay $26 extra when you're in the rears? But the litigant does a job of explaining it. It has to do with the fact that Barrier Busters was telling him that they were going to make a certain amount and that he needed to pay the $26 more because the amount that they were going to make would leave him in a deficit of $26. So that's why he made that statement.
But it's still in process.
Okay. So
But
Barrier Busters is supposed to send a check, is what you're telling me.
Yes, sir. $742.
Do you have any communication from Barrier Busters?
This morning, my social worker told me he got an email stating that the payment is in process. Whatever that means. They said the payment is being processed.
Okay, I'm not sure where. Okay, so yeah, he's here. Okay, so Mr. Hussein is on the premises. There are times when the court will have a Zoom hearing or hearing by Zoom, and if the litigant doesn't feel that they have a secure Wi-Fi, they don't have, good connection with Zoom. Zoom can be very tricky. It can be very annoying. Okay. So please believe me, I understand. I am not casting any dispersion on anyone because you can have great Wi-Fi, which I have great Wi-Fi, but because I live in the hills, My Wi-Fi has issues, and consequently, there are times that my Zoom is not doing so well, or if I have too many people on the Zoom, it will slow up. And then, if I'm showing my camera, it will break up and do weird, stupid things. It can be very annoying, right? So, litigants still have the responsibility of being in court regardless. You can't just say, oh, I tried to get on Zoom and it didn't work. You've got to make sure your connection works. And if it doesn't, then you come into the courthouse. It looks like that's where he is, in one of the rooms in the courthouse. Um, at first I was wondering if he was like somewhere else, but looking at it, he's in the courthouse. He says his social worker is getting him these services and helping with the rears for the payment. This is great to know. So for those of you who live in Michigan, take note of barrier busters. And he says another one, just take note of what it is because it may be helpful for you, and look up the ones that are necessary in your location. One of the things that I work really hard with my clients, because I work on the transaction of selling real estate, not I do landlord tenancy in the terms of being the landlord of my own properties, but I don't necessarily do it too much for other clients. That would be property management. I do some of it, but I mostly let them, run their own show as landlords. I'll give them some advice here and there, but that'll be about it. And I only have about a handful of clients now that I actually collect rents for, and I want to shake that tail because it can be cumbersome. But nevertheless, if you are a tenant, please make note of these particular services and find the ones that are relevant for your area. Because if you're ever in dire straits, it's better to pay and stay where you are than trying to relocate. It's really hard to do that. And one of the reasons is because you have an eviction on your file, right? If you go through this whole process and you get evicted and now you have a record of it, trying to get into a new place is going to be even harder, or you're going to be settling on the quality of place because of the eviction, and so forth and so on. So do whatever you can to mitigate any damages that you may have and to solve any problems that you'll have. So use this time to gather resources if need be. Maybe you'll need them in the future. Looks like Michigan, if not all of the nation, I don't know, there's barrier busters, so that's one
That's
potential.
from
Okay.
this morning. That's from this morning communications.
Gotcha. And that's why you paid the 1,300,
And $26.
whatever. Okay, because that's what they told you.
Yes, sir.
So let me ask you this. Of the 7,
And Judge Simpson must be in a good mood because he does this a great deal anyway. He's a great judge, but don't take this as if this is the way court goes all the time. If you're going to make a representation, have something to back it up. It's called a P&A, right? You make a point and then you have the authority for the point. If you're going to represent that you have this particular entity willing to pay a certain amount, have that communication in writing so that you can submit it to the court, submit it to the landlord, let them know. Listen, we don't even need, maybe should have, well, he said he had the communication this morning, but it would have been better if he had it maybe a day or so before and they could have rescheduled the hearing and calmed the landlord down and sent them over the communication. But whatever you can do to have something in writing or to show evidentiary proof of what you're speaking to, please do bring that to court. Don't leave it. He is doing fine. Judge Simpson's not, questioning him too far on the legitimacy of what he's saying. I'm just telling you, forewarning you for all other circumstances, you may in fact need to have that proof in hand. So always have it. There are so many litigants who go to court and say, oh, I have it at home, or I left it, or no, they should have it. Bring it for yourself and bring copies for the court.
766 plus whatever your September charge is, how are you going to pay that?
September's not due until September not due until next week. September the 5th is the day to pay that. September the 5th.
Another thing I saw in the chat was someone said rent's due on the 1st. Rent's due on the 1st, not the 5th. No, rent is due based upon your lease. Your lease could in fact run from the 5th to the 5th, because if you had a proration that you started your lease some other time within the month, then your rent is due as it's stated in the lease. Atypically, every landlord wants the money on the first. This is true. However, there may be instances where the landlord has leased out the property after the first, and consequently, they're running leases later in the month. So that was a good point. But usually, it's due on the first. I don't necessarily know that his is actually due on the fifth. He makes his representation, but he may understand it differently. Nevertheless, make sure you know your lease agreements and all its terms.
So you can pay your September rent after the 5th.
I'm hoping I can. I really hope so. Also, I'm being followed by,
What is that based
Hawk
on?
as well.
Hold on a second. Stop this for a moment.
Yes, sir.
You get a check on the 5th? Is that what the deal is?
No, I get, disability.
It's
Okay.
a check.
All right. So, okay.
That's money.
And so your money comes in on the 5th.
Yes,
Okay. So you could make a payment on the 5th or shortly thereafter. Is that
I
correct?
should be able to pay September on time. Usually, you get September the 5th to pay it. Usually, it's due September the 5th.
Okay. Here's what I'm going to
I've
do.
been living there for 12 years. I've been paying September 5th for 12 years.
He said two separate things. He said usually they give me until the 5th to pay it. And then he said usually it's due on the 5th. Those two things are not the same. They don't mean the same. Only one of them can be true. Two of those two things don't they're not able to coexist, because typically you have a grace period. So it sounds like he says he has a grace period till the 5th, and that's when he always pays. But anyway,
Gotcha.
cute little
Okay. So
double
here's what
talk.
I'm going to
Very
do.
much.
We need to check into that Barrier Busters check, and you need to let them know that they need to get that to the landlord or get you some proof that they're paying it. Okay.
Okay,
And then
Mhm.
if I adjourn this out to the 8th,
Proof that they're paying it. Yes.
2023
Yes.
at 12 p.m., you should, then what I want you to get paid is your November rent, or I'm sorry, your September rent.
yes, sir.
Okay. So you're to pay your September rent by the 6th, because your check comes in on the 5th.
Yes, sir.
Okay. And then get something confirming that Barry Busters is paying that remaining balance.
Okay,
Okay.
yes, sir.
Your Honor, if I
And
may,
so,
um,
yes.
if we were to request a judgment right now, he would have until the 11th to pay anyway.
Right, but he wouldn't get a judgment at all if Barry Busters had paid. So the problem here is that he said he paid in full.
Mhm.
There's a holdup, I think, in writing the check, the other portion. So they told him to pay the 13. Had they paid it or written a check that day, this case would have been dismissed.
Okay,
I mean,
and
so counsel, I get your point, but I think in this circumstance, it might be sort of patently unfair to do that to him.
Okay. Can
Okay.
you please repeat the name of the rental assistance program that
Barrier
management?
Buster.
Barrier Busters.
Okay.
And also, I'm being followed by, Hawk as well.
So what counselor is saying, Counselor Laura is giving me the impression that Attorney Levine, who has put in her name, that she is there in representation of, she's there for Attorney Levine. So this happens a lot of times, that your co-counselor or your office attorney will come to a case on your behalf because you're in a different trial or so forth, and you're double booked, and so you send another attorney to represent you as an attorney. So that's not abnormal. What she's presenting is if that attorney gave her the assignment, like, we want a judgment, this has gone on too long, he hasn't done it, so just make sure you leave there getting a judgment. Because she's like, well, why can't we just do the judgment, Your Honor? And what she's saying that is 10 days from the 1st is the 11th. And what happens is that the judgment would give him until the 11th. You give him 10 days, right? They enter a judgment today. He has 10 days to make that payment. If he doesn't make the payment, then they start the writ of execution process. Writ of eviction process. But the judge is, giving her pause to that, because he's saying, truthfully, we should be doing a dismissal at this point, because he's made the payment. He's done some good faith in making a payment. So that's probably why the judge is working with him. He's showing that he is making efforts to cure the errors here, the arrears, and he's has a third party making the remainder payment. Now, landlords don't always have to, or they don't ever have to accept third-party payments, such as like Section 8 relief payments. Um, they don't have to wait for those payments. So if you are going to employ someone else to help you, a different entity to help you, please make sure that you are staying in communication with them and making sure that they realize that, things need to be timely and where you are in the process. Because if you're in pre-eviction or you're going through an eviction process here, you don't want them to, issue the check so late that you're now being evicted. Looks like he has a social worker that's working on his behalf, so surely they're making those communications as well. For your interests, you were probably advocating for yourself until you have a social worker or someone else that can do it. I'm just giving you a suggestion that you ensure that you continue to work with them and getting that payment through, because the landlord does not have to wait. We've seen it in Judge Middleton's court time and time again, where some third entity is making a payment, but because they haven't done it within a time frame, the process of eviction moves forward. And if they don't get it done before the time frame, they have to get out of the property. So you don't want to be in that situation if you don't have
Right.
to.
So let's do that. And clearly, if everything's not paid, then yeah, maybe I'll consider a judgment on the 8th on it. Okay. Thank you.
And that
And
turns
what time
around.
did you say that hearing was set for?
Pardon?
What time was the hearing set for?
At 12 noon.
No.
Okay, thank you.
Can I ask you a
So-
question, Your Honor?
Oh,
Sure.
okay.
What does judgment mean? I'm ignorant. What does that mean, judgment? Like,
A judgment?
yeah.
Well, we're not doing that today, but what that would mean is I would be issuing an order saying plaintiff owes a certain amount.
No,
Okay.
defense owes
Right.
plaintiff a certain amount.
And then upon them owing a certain amount, I would then also say you have to pay it at a particular time.
Okay,
Okay, but we're not doing that today.
okay,
And furthermore, it goes on your record. When they pull your name, judgments are a part of your background. So you want to avoid having financial judgments against you. They can affect you getting employment, depending on what field of employment you're in. And of course, in this instance, when you're trying to get a new property, it shows up, and that becomes a problem in getting new property or renting out a property in the future. The landlord can use that particular information to decline your application for the new property, that if you should so move forward and relocating. I'm not sure. I think they fall off a few years down the line. I'm not sure the actual time frame, so you would double check that for your own location to determine how long judgments stay upon your record. It might be the judgment, because they're financial and they're with the court, they might stay open as long as they are unpaid. But once they're paid off, I think they fall off after some length of time. So you need to double check that for yourself. Yeah, and you want to avoid having a judgment against you when you can. Thankfully, he's giving him time frame where he's not getting the judgment now. But one of the things he is doing is losing time in some regards. So if he got a judgment today, he would get it on his record. So like we just talked about what that means, but he would get the 10 days to make the payment, which is what the counselor was saying. Well, if we give him the 10 days, he has until the 11th. The judge is now saying, well, he wants to pay it on the 5th. He shouldn't have a judgment against him. So he wants to protect his background, is what he's doing, protecting his record. And he will come in on the 8th. And by the 8th, we should have resolution to this. That's 1 week from now. We should have resolution to this. He should have made all payments. If no payment is done by the 8th, then we'll go into the process of entering a judgment, have the 10 days for curement. He would have till the 18th or so. And then if he makes the payment by then they'll do a dismissal, but then the judgment becomes a part of his record. So the judge is really preserving his record as much as possible in this instance. However, he is getting a shorter period of time compared to what she was suggesting, because he would get until the 11th to cure the payment, though he only needs until the 5th to make September's payment. And hopefully barrier busters will be able to make the payment within the next few days. That would be the entity that would be of issue.
Okay.
yes, sir.
All right. Thank you.
So next Friday at 12 o'clock?
Yes, next Friday, 12 o'clock.
Thank you, Your Honor.
You're welcome. Court calls the
That's
case of Westridge Mobile Home Park versus Cindy Alvarado Lopez.
Good morning, Your Honor. Laura Kruby on behalf of plaintiff Westridge Mobile Home Park.
Okay, it's Ms. Lopez.
Hello, good morning, Cindy
So-
Alvarado.
All right. So the last time we were here, you were to pay $800 and then you were going to pay $400
See?
today. Has that been done?
Your Honor, she has made an $800 payment, but she still had a past due balance.
Right.
The 400?
What do you have her owing at this point, counsel?
I have her owing $1,429.92 plus court costs of $170 for $1,599.92. However, that does include September.
Got it. Okay, Ms. Alvarado, what do you have to say to that?
What?
Yes, hello.
Hello.
So what I'm hearing the attorney represent is that she said it does include September, so it sounds like she's about $400 a month. And maybe she had 3 months in the rear, so she made the 800 to cure 2 of those months. Today, she's supposed to make a $400 payment to cure the 3rd month, and then she has the $400 for September's month, plus her court costs. So is that right? 800 for the two, and then 1,200 for the 3rd month cure for today. Maybe not 400 a month. I'm not sure.
Oh, yes, I made payment today to the 400 in the afternoon, so just, and now I'm working. But I can pay everything, the rest, and plus the September rent for September 15, because I received my paycheck from my work.
Oh, okay.
Okay,
So how much?
I want to make sure I'm understanding you. You can pay off this entire balance. When can you get that done?
For September 15, because I received my paycheck from my work.
Okay, so you can get it all paid on the 15th?
Yes, yes.
Okay, so here's what I'm going to do. I'm going to find no tribal issue after hearing. I'm going to grant a judgment for possession for a total amount of, I think you said, counsel, $1,599,492.
That is correct, Your Honor.
All right, so I'm going to grant that judgment, but I'm going to indicate that the writ won't issue until the 15th.
Sounds good, Your Honor. Thank you so much.
Okay.
All right, you got that, Miss Alvarado?
Yes, I got it. Thank you.
Okay, so you got to the 15th to get it cleared up.
Yes, okay. Thank you so much, Honor.
Thank you.
Okay.
Court calls the case of Whitaker Oaks versus Adam Gimmett.
Good morning, Your Honor. Laura Ruby on behalf of plaintiff Whitaker Oaks.
They are not checked in.
Adam Gimmett, no response. Would you like to be sworn?
Yes, Your Honor.
Mm-hmm.
Do you raise your right hand? Do you solemnly swear or affirm testimony you're about to give will be the truth?
Okay, so tenant is not on set, or no, on set. Tenant is not in the court. Tenant is not on Zoom. So the attorney is going to make representations to the court. Consequently, she's getting sworn in to be under oath in order to testify to the court.
Truth, the whole truth, and nothing but the truth, so help you God.
I do.
All right. What's your claim?
Your Honor, this matter is for possession only with rent to retain in the amount of $1,465.77 with court costs of $160 for a total of $1,625.77 with writ to issue in 10 days. And to my knowledge, the defendant is not a minor, not in the military, nor incompetent. And to my knowledge, the defendant has not indicated that they are applying for any rental assistance programs at this time. And as a failure of defendant's failure to appear, plaintiff would like to move forward with the default judgment.
Judgment to the plaintiff. That is by default for possession. Redemption amount is any amount requested with a writ to issue in 10 days.
Okay, so default judgment, 10-day time frame still good, and redemption amount. So if the tenant pays that redemption amount within the time frame, they will have the right to stay in the property. The factors that she represented was elements such as the tenant has not expressed any Veteran Affairs affiliation or any other rental assistance affiliations. So consequently, they're the only ones responsible for the rent, or the only ones that are going to be paying the rent in and of themselves. So consequently, Judge, we don't need to delay for any association or agency processing, is what she's represented to the judge.
Thank you, Your Honor. I believe that is.
Thank you.
all.
That's it. Have a great holiday.
Bye-bye.
Great. Okay, yeah, this is for before Labor Day.
That it?
Happy Labor
That's
Day
it
to
till
all
11. Court
of
stands in
those.
recess.
All right, we're in recess. Okay, perfect. So since court is in recess, we'll take this time to cut the day, and we'll move on to the next a little later. But anyway, hopefully we've learned a few things. Landlord tenant law has a tendency to be kind of repetitive when we go to court. Case to case is similar, basically non-payment, right? But there are sometimes we get little tidbits of information that are helpful to us. In this instance, hopefully some of the tenants out there are able to learn of some other agencies that are willing to help in helping you make those payments. Investigate that for yourself. Obviously, I don't deal with tenant relief per se. So, make sure you investigate that and research it for yourself. Make a list. If you are a tenant, just make the list now, even if you're not in the rears or have any issue, so that if an issue comes about, you know where to turn to and you're not scrambling. It helps you to be a little more proactive. And the reason why I say that is because COVID, or I guess we call it the panorama, sorry. Hopefully I won't get dinged, but whatever. Because of that time frame, we've learned, quite honestly, what it feels like to live paycheck to paycheck. Many of us have had that experience regardless of the pandemic, but everyone in the United States got to a point where we were shut down and they most likely were not working unless they were a part of our responders and our workers. So take away the lesson that you're not guaranteed your job. The company may shut down for whatever reason, and you may have to get laid off. You can do a phenomenal job and find yourself without a job, just all the same. And you just might need to use that relief. So we'll get the list together now, just in case you need it. And you may not be the one who needs it. Maybe you're listening to this and you're doing it for your own benefit, but someone will come down the line and ask you, and you happen to be a great resource for them. Okay, so check out, make a list. Hopefully it's beneficial to you or someone in your sphere of influence. And I thank you for watching me today. Okay, how you like my hair? It looks funny, huh? It makes me look like I don't have a neck. I was looking at that earlier. I was like, oh gosh, I don't have a neck in this thing. What is going on? What can I do? But I am having fun with it. So I'll enjoy it for a little while longer. All right, Lyric Armstrong here, your real estate agent and advocate. I've had a great time with you. Make sure you like, share, and subscribe if you've done the same. By all means, make sure that others are learning from our experiences, because that's what we're here to do, learn as much as we can relative to real estate and the transactions that acquire in court, from failures to perform to specific performance inquiries to landlord tenancy issues to probate matters. So share the love and let everyone in your sphere know that we are here. All right, thanks. See you soon.